Morning, everybody. I will go ahead and kick things off now. My name is Professor Jeff Biller. I'm at the United States Air Force Academy. I teach in the Department of Law, and I am the co-director of the Law and Technology in Warfare Research Cell, where we're partnering with Headquarters U.S. Space Force and U.S. Space Command to bring you this series of webinars. So now, without further ado, I'd like to turn it over to for our main item of today, the intentional reversible satellite interference, a use of force in space. I think this is an extraordinarily important and relevant topic. The Trump administration has stated that any harmful interference with or an attack upon critical components of our space architecture that directly affects this vital U.S. interest will be met with a deliberate response at a time, place, manner, and domain of our choosing. I think so, therefore, determining what those lines in the law that would permit such responses is a key endeavor. So our first presenter for today is going to be Major Adam Mudge. Major Mudge is the Chief of Space Law for Headquarters, United States Space Force at Peterson Air Force Base, Colorado. He holds an Air and Space LLM from McGill University and also teaches space international operational law at both the 319th Combat Training Squadron and the National Security Space Institute. He was previously an instructor of military justice at the Air Force Judge Advocate General School from 2015 to 2018. He has deployed as a deputy legal advisor to the Combined Air Operations Center at Al Udeid Air Base, Qatar, and is also deployed with the Combined Joint Interagency Task Force 435 supporting detainee operations in Afghanistan. Following Major Mudge this morning will be our second presenter, Major Brian Green. Major Green is the Chief of Operational Law for Headquarters United States Space Force at Peterson Air Force Base. He also has an Air and Space LLM degree from McGill University and has served as the Chief of Space and International Law for the then 14th Air Force at Vandenberg Air Force Base from 2014 to 2017. From 2017 to 2020, he taught operations and international law at the Air Force Judge Advocate General School, during which time he also deployed as a deputy legal advisor to the Combined Air and Operations Center at Al Udeid. He also coached the Air Command and Staff College Space moot court teams. So now I'm going to take a moment to bring up Major Mudge's slide, and I will turn it over to him. And as promised, I'll get you some of that information into the chat box.
All right, sir. Appreciate it. Good morning, everybody. Before we get started, I did just want to say a quick thank you to Professor Bill and his team out at the Air Force Academy and the legal team at the United States Space Command for hosting this series of webinars leading up to the conference next year, and for inviting Major Green and myself to participate. We definitely appreciate the opportunity to kind of discuss these interesting and frankly really important legal issues surrounding the use of force in the space domain. I also do want to foot stomp at the outset that the opinions expressed by these slides and by Major Green and myself are our own opinions. They're not necessarily reflective of the Department of Defense or the United States Space Force. So there's your typical legal caveat as on slide 1. So to dive right into this topic, we've titled our discussion for this morning, Intentional Reversible Satellite Interference, the Use of Force in Space. However, even though that seems to be pretty precise, I think it's worth taking a little bit of time to frame the discussion and to explore the underlying legal principles that kind of make up the pieces of this puzzle. Because as you start applying the facts of any kind of satellite interference to this legal structure, these terms, which can often be pretty ambiguous in international law, play a really important part in how we frame the discussion. So if you'll advance the slide, sir. I've kind of restated the question, or more precisely refined the question on slide 2. So this is a little bit of a restatement of that initial question, or really a refinement of it. So under what circumstances, if any circumstances, could purposeful reversible satellite interference actually rise to the level, under international law, the use of force? When we say purposeful in this discussion, we're really conveying the idea that the interference is knowing and intentional. So in other words, it's the natural and intended consequences of a state action. We're not really going to talk about the difficulty of attribution for space activities, and that's often a problem, especially in other domains like the cyber domain. we're going to kind of assume that for purpose of this discussion. And when we talk about reversible satellite interference, we basically mean non-destructive. So we're not talking about kinetic kill, anti-satellite weapons, or directed energy or laser technology that damages optics or destroys sensors or anything like that. Those situations are frankly a lot easier to comprehend under international law. So by reversible,
Uh-oh, did we lose Adam? Until he comes back, you want to take it over, Major Green?
Very well. All right, so.
Oh wait, I think we got him back. I think we got him back.
yeah, I apologize. I'm not exactly sure where I dropped out.
You were just about to define reversible.
Okay, so basically, what we mean by reversible is non-destructive. We're not talking about kinetic kill, anti-satellite weapons, or directed energy that destroys optics or sensors or anything like that. Those are a lot easier to comprehend. We mean temporary effects that can be ceased and thereby return the satellite to normal operations at some later point in time. So if you'll advance to slide 3, sir. When we talk about the use of force, that term itself, that of course has a unique meaning under international law. And is basically prohibited in virtually all circumstances, save a few exceptions. We get that primarily codified in the UN Charter in Article 2.4, where member states are directed to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. But that's not the only place it exists. We also have this prohibition as a peremptory norm, Yes Kogan's. It's a duty that under international law from which no derogation is permitted. So it's an obligation owed to all and is non-derogable in both in custom and treaty. We want to distinguish this though from other potential international law violations when it comes to intentional reversible satellite interference. Right, because you could cognize that, you can make the argument that this is a violation of international law from some other obligation. And that could be, if we think to the Outer Space Treaty, due regard principles or harmful interference principles, or to the ITU, harmful interference provisions, or the general principle of non-intervention. So there's other bases we could talk about this, but here we're focused on the wrongful use of force in a jus ad bellum pre-armed conflict context. Okay, so if you'll advance the slide, sir. So it also raises the question of why do we care? Why is this trigger so important? Why is the issue of satellite interference and its use of force implications in the space domain important to us? And it's really important to us because that is a trigger point for an international law violation that opens up the rights and privileges of the injured state to seek redress under international law. But this particular violation, the wrongful use of force, importantly, would allow a state under customary international law and the UN charters we discussed on Article 51 to respond with force in self-defense. Of course, there are certain caveats we're not going to talk about in necessity and proportionality and all that stuff, but it's important because if intentional reversible satellite interference rises to the level of the use of force, states are legally allowed to respond in self-defense with force. And the ramifications when states choose to use force are huge. So the trigger of when this interference becomes a use of force is quite important. Although as we discuss this, I think we'll all conclude that it's incredibly ill-defined in the space domain. So seeking some sort of shared interpretive framework under international law is really important. and this is the point always too with coalition partners, where we need to take a brief moment and note that this is just the U.S. interpretation, right? The U.S. has stated consistently that it reserves the right to respond with force and self-defense to any use of force against it. However, if you know, from the context of coalition partners and the International Court of Justice, frankly, the majority views that the use of force has got to reach a certain level of gravity. It must be grave enough to be considered not just simply a use of force, but also an armed attack before that right of self-defense under Article 51 of the UN Charter kicks in. So a quick caveat for our US position. All right, if you'll advance the slide, sir. So what is a use of force? How do we define that term in this question? Well, it's a term that we often use, we often employ it, but it's not really expressly, singularly defined under international law in a precise manner. Luckily, we do have an International Court of Justice case from the mid-'80s, the Nicaragua v. United States case, that aims to clarify what exactly that means. And taking that case into context, most scholars agree that uses of force generally pertain to some sort of arm.
All right, I think Major Mudge has gotten stuck again. In the meantime, Major Green, why don't you go ahead and take over?
All right, so yes, as the ICJ held in the Nicaragua case, usually use of force does involve some kind of armed force, as Major Mudge was saying, some type of organized military effort involving weapons that's going to result in death, personal injury, and property damage. Those are kind of the hallmarks of the use of force. And yet, the ICJ made certain distinctions between the various activities that were going on here. And that kind of dealt with the directness of the United States responsibility for what was going on in Nicaragua via the Contras. We had been funding these groups, and the ICJ said that that was not itself a use of force, but that some of the actions that we did in arming and training them to carry out acts of sabotage or other things in Nicaraguan territory did constitute a use of force. And Major Mudge, it looks like you're back on now. Would you like to pick it back up from here?
I can take it back up. I guess given the technical difficulties, if I do drop again, I might phone a friend and let Brian step in. I don't want to continue to delay or disrupt the. I apologize again for technology.
Yep, that's all right. That's life under COVID, right? So,
yeah.
All right, just keep pressing, and then if you drop out again, yeah, we'll just turn it over for the rest to Brian.
Copy, sir. What we do know from the ICJ case is that there are gradations of the use of force, and that takeaway will inform the rest of our discussion. There are more grave forms, and they define in that case some of the most grave forms. Particularly acts of aggression, which the General Assembly at the UN has discussed and given examples of. And it also kind of explains certain circumstances that are and that are not the use of force. So sending proxies to do what would otherwise be a use of force is still a use of force. We also learned that arming and training and all of those things that go into supporting those mercenaries is also itself illegal as a use of force. However, the mere supply of funding or anything like that is not a use of force. If you'll advance the slide, I wanted to throw up some of the terminology from this General Assembly resolution, which was cited in the ICJ case, because I think it's illustrative of some things that we know are severe uses of force. And these are things that we can kind of hang our hat on and say, yes, this is a use of force agreed upon. This is non-binding, of course. This is also non-exhaustive. However, it is illustrative, and so I won't read them out, but one that stands out is an attack by the armed forces of the state, of the land, sea, or air forces, or marine and air fleets of another state. And I think by extension, we can include space fleets here. So attacks against the military forces are very clearly acts of aggression. But that just drives the question of, well, what is an attack? What is that use of force look like? And if we advance one more slide, we can consider that from the military perspective, what an attack on our fleets or our Marines or air fleets or space fleets would look like by consulting an unclassified portion of the standing rules of engagement, which define what a hostile act is that allows us to take self-defense measures with using force. Unfortunately, that just is described as, again, an attack or another use of force against the United States or forces or property, et cetera. So it's getting a little circular, and the terms are not being clearly defined either in international law or in domestic military policy. So given this difficulty with defining precisely the trigger point for a use of force, especially in the context of space, it's probably helpful, I think, to consider how states treat this trigger point in other domains, specifically the cyber domain, because of the similarities that the cyber domain holds with space. So if you'll advance to the next slide, sir. Cyberspace is an apt comparison, I think, because of the physics of it. It's not like the other domains, and oftentimes we're talking about forms of directed energy or electromagnetic energy, not your traditional kinetic domain. It shares attribution issues and concerns. It's an invisible domain in a lot of aspects, and so what I think is helpful is to consider what states have said about this, whether that's from their attorneys general, from legal advisors or ministers, considering where is the trigger point for the use of force in the cyber domain. And what we see is that over time, specifically on this slide, both the UK and the United States agree that cyber activities can amount to uses of force and trigger that right of a nation to defend itself with force under international law. And the US has been pretty clear that this analysis requires an investigation of lots of different factors, and that includes the context, the actor, the target, the location, the effects, et cetera, including considering whether the effect is kinetic or non-kinetic. They have not expressly said that a non-kinetic effect from a cyber effect can never possibly be a use of force, and we'll see in a second, other states have gone much farther than that and overtly said, no, it can be a use of force without a kinetic effect in the cyber domain. So given that lead up, given those contextual definitions to frame this question, I'm going to turn it over now to Major Green to kind of further discuss some viewpoints of the states, the relevant states here, in addition to the US and the UK, and then also to begin to build out potential legal frameworks for interpreting whether these types of actions in space might actually amount to a use of force. So Brian, over to you.
Thank you, Adam. So if we go to the next slide, we can see that the opinio juris that's coming out on the matter of what a cyber attack would be and how we might be able to treat that as an armed attack is not limited to the Five Eyes or the Anglosphere, but it's definitely coming out there among our other coalition partners as well, our other close allies, such as the Netherlands, France, and Japan. And basically what they're looking at is the idea that there could be some very serious consequences, some very severe effects, even if it doesn't result in immediate death, personal injury, or property damage, although those certainly would help a cyber attack to rise to the level of an armed attack, potentially, or a use of force. But they're also starting to look at things like, well, what if it has long-term damage to the financial system? What if it intrudes on a state's ability to perform its sovereign functions? Policing, taxation, maybe the election system in a democratic country. And so as a result, we're starting to see more and more states taking the position that, yeah, given the major consequences that these types of actions could have, these are situations that we might need to consider a use of force and to be authorized to take actions in response. Not that it will likely or frequently rise to that level, but it's certainly not out of the realm of possibility. And there are certainly plenty of ways that it could also be characterized sub-use of force. But what it all comes down to is kind of what the ICJ in the Nicaragua case characterized as the scale and effects test. And you see different variations on that, different degrees of specificity. Okay, how large of a scale does an attack have to be before it's an armed attack? What do the effects have to be? How badly does the target state have to be affected before the action would be judged a use of force or an armed attack? And we see also in here from Prime Minister Abe's remarks that premeditation is, of course, a significant aspect of it. Just as our initial question stated, we're talking about the deliberate or the intentional interference, albeit reversible interference with satellite systems. And so if this is part of a coordinated, deliberate effort by a state, then we have the state responsibility there and the possibility that this could be a use of force or an armed attack by that state. If we go to the next slide, please. All right, so here are a few other ways that you can try to analyze whether satellite interference is actually a use of force or an armed attack. And the first one there, instrument-based, is basically looking at what is used to perpetrate the attack. And is it something that's owned by the military? It's something that would be considered a traditionally military weapon. And I think that this particular means of analysis is a bit too narrow. Lieutenant Colonel Sarah Mountain from the US Air Force talked about these different approaches in her article that came out in 2014 about satellite interference. And these are some of the things that she looked at and analyzed. But there are a lot of things that can be done and that states are doing to try to mask their official military involvement in activities, sometimes using third parties, using so-called just patriotic citizens movements, troops that are on vacation from the Russian military in Ukraine that Ukrainians are characterizing as an invasion, So we want to look at not only what is the means used, but then some of the other things as well. The next item on here is target-based, and what is it that's being attacked? So how important is that target? And this is important to consider too, because it's going to get into the degree of how this affects perhaps not the territorial integrity as we think about Article 2.4 of the UN Charter, but the political independence or the sovereign functions of a state. And so if you have a significant national security satellite of a state being targeted, then that could be something that is more likely perhaps to rise to the level of an armed attack than an action that takes place against a commercial satellite or something that doesn't really implicate the national security of the targeted state in the same degree. But this is also somewhat limiting, or perhaps it might give people too broad an argument to respond if we're just looking at what the target is. And when we're talking about temporary reversible interference, however deliberate, there are different degrees of that. It may be that somebody is seeking to gather intelligence to try to figure out if they can intrude into a system, but not actually causing impairment of its function, not actually disabling it for any length of time. And so there are gradations of the potentially harmful activity that kind of run the gamut from mere intrusion and information gathering to something that could actually deny the function of that system or service. And so we want to be considering all those things as well. And that really gets us into the effects-based. It's not just who's doing the action or what they're using to do it. It's not just the satellite system or service that they're going after, but then what are the actual consequences of that? So all of these are important, but the biggest one is effects-based. And I think there's been a lot of concurrence between the US and NATO allies, other coalition partners, that this is the main area that we need to focus on. And you saw it in some of those statements from the previous couple of slides as well. Could we go to the next slide now? All right, so let's go next into the Schmidt factor. So many of you are familiar with these. It came out in a paper by Professor Michael Schmidt, then of the Naval War College in 1999. And again, as with some of those previous statements, it was looking primarily at when could a cyber attack rise to the level of an actual use of force. And these are the factors, could you back up please, that Professor Schmidt came up with that try to give some more detail to that scale and effects type of test that we talked about from Nicaragua. And the first one up there is pretty straightforward, and I think is the one that does most of the work here, and that is severity. Looking at the overall outcome, does it actually result somehow in death, personal injury, property damage? Probably not going to be the case with any sort of reversible temporary interference. But as we saw from some of the statements a couple slides ago, it may be that there could be actions that cause such severe impacts on infrastructure, on the economy, on the financial system, that potentially reversible interference, if it is sustained and deliberate and targeted at something that has that would produce severe results, maybe we could be looking at something that satisfies that factor. Next is immediacy, and that's basically looking at how quickly does the action take place. With space, as in cyberspace, this is something that can be immediate. It doesn't require a lot of build up mustering troops across the border. Professor Biller, please go back, thanks. When you're talking about signals sent over the electromagnetic spectrum, this is happening potentially at the speed of light. So the action may be very immediate and it may occur without warning. So this is something that, we probably have a lot of immediacy. And what Professor Schmidt had said is that traditional armed attacks and uses of force could be very immediate when they're launched. And I would say with space and cyber, probably even more so if they are done without warning. Directness is a factor that refers to the nexus between the action, the interference, and the harmful consequences downstream. So, and this is an area that I think it may be a little more challenging for the temporary reversible interference to satisfy, because there may be a direct effect on a particular satellite signal, but what harm is that going to cause to the end users? Is that going to be mediated by any intervening actions? If you have somebody interfering with a global navigation satellite system signal, that may make it more difficult to get that signal, to figure out your position, navigation, and timing data, but it's not necessarily going to make airplanes just fall out of the sky because they can't pick up GPS. And so I think the directness is an open question. Most satellites up there in space that might potentially be affected by this do not have people on board, the International Space Station being the current big exception. But most of the ways that space systems help us out on Earth are going to be mediated various ways. And so there may be immediate effects, but do they actually cause directly severe consequences to people on Earth? And I think that's an area where it's pretty challenging to argue that this reversible interference could be a use of force in most circumstances. Then you look at invasiveness, and of course, as we saw again from the Nicaragua case, what matters in the international context is the degree of invasion. You know, is it actually affecting a country's territorial integrity? Are you trying to carve off land? Well, space systems aren't going to do that standing alone, or attacks on space systems. But then you start to look at, well, what about the political independence? What about the sovereign authority of the state? Are you interfering with the government's ability to perform its core functions? And that's an area where if satellites that enable a state to perform its core functions are being interfered with to the point that a state is unable to perform them, then maybe we could have an argument for invasiveness. Then you've got measurability. How do you quantify the damage that's being done? Kind of think about attribution in this context as well. You know, how well do you know what state is actually responsible for the interference that's going on? May or may not have good intel to pinpoint that. But measurability is more focused on the consequences of it. And so if you are having one of your sensitive spy satellites temporarily lazed or jammed or something, and it's not able to take imagery, or it's not able to send back information to Earth, how do you quantify that in terms of monetary value, in terms of effects on our ability to perform our sovereign functions and so on? Even if we could measure it, is that something that we necessarily want to be presenting and making known to the international community? Is that something that we would try to bring up in diplomatic negotiations of, hey, you cost us this much, here are the effects on us? We don't always necessarily want to let the adversary know what sort of effects they're having on us. That might actually be more dangerous than saying nothing. And so measurability can be a challenge as well. There may certainly be ways that one could quantify it in terms of lost economic output, or if there's a widespread disruption to the GPS constellation or something, for example. You know, what sorts of economic activities are reliant on that would become unable to do it. And then presumptive legitimacy is the last item, and that's, is the activity that the state is doing something that would be considered normally within its rights to do? And I think we've got probably some varying views on what that would be, but you want to look at the overall context, what the state is doing, where is it conducting the interference? Is it doing it in what it might contend would be a defensive manner, trying to maybe only interfere with another country's intelligence, surveillance, and reconnaissance satellites when they're over its own territory? You know, not that it necessarily has a right to interfere with those per se, but it has a right to protect its own activities within its territory, or privacy of its citizens, or what have you. Then maybe there could be an argument for that, as long as it doesn't spill over into harm to other countries. So those are all some factors to consider, and we want to consider all of them when we are analyzing whether a particular instance of interference with a satellite would constitute a use of force. And now we can go to the next slide. So to wrap it up, I've got a few thoughts, and we can build these out. If you advance one more, sir, please. Okay, so you know, main thing is that even if deliberate, reversible satellite interference would rarely constitute a use of force or an armed attack. If it's not something that is even damaging the satellite itself, let alone being likely to cause personal injury, death, or property damage on Earth or elsewhere, you're probably not going to rise to that level of severity that would qualify it as a use of force or armed attack, certainly as traditionally understood. If we go to the next point. But it might be that there could be intangible consequences,
Hello?
or other variety, that might qualify as severe, and some states have been on record as saying that there could be circumstances, at least where a cyber attack would rise to that level. And certainly by way of analogy, we would contend in our personal capacities that we could see situations where, just as Professor Biller quoted President Trump's statement about interference with our vital interests, those aren't defined, but it is up to the senior political authorities of a state to determine what those are and when they have been violated. We go to the next bullet. All right, getting away from the core question a little bit about interference standing alone, there are still some ways that we could see responses being justified. And even if the reversible interference would not itself, standing alone, constitute a use of force or an armed attack, it's possible that it could be done in support of a use of force or armed attack as preparation for an invasion or another attack that does result in loss of life and property. And so as Major Mudge had detailed, we have that category of demonstrated hostile intent, or in the UN Charter Article 2 sub 4, the threat or use of force. And it's generally recognized that if there is an imminent threat of armed attack, then countries are justified in using force in anticipatory self-defense in order to prevent themselves from being attacked, as long as it's imminent. And perhaps the reversible interference could be a signal or a prelude to the armed attack that would justify taking anticipatory action. If we go to the next build. Okay, and then again, kind of a separate category here, but we've been talking about the use ad bellum context before hostilities have broken out, but all the discussion about how usually deliberate interference wouldn't constitute an armed attack on itself doesn't mean that if you're already in a conflict and somebody is doing, your enemy belligerent is conducting reversible interference against you in support of their end of the fight, then if you have rules of engagement that permit them to be targeted, and they could be targeted offensively without a particular predicate act on their part that would itself, standing alone, justify use of force in self-defense. So with that, I will open the floor to discussion. I see we had a couple of questions in chat, and let's see. Looks like Svenja, nice to hear from you here. Talked about international interference, and does that mean that you need proof? And if yes, what level of proof would suffice? So yes, I would say that intentional interference does require some sort of attribution to be able to make that finding of intent. Depending on the action, I know there are certain things potentially in the cyber context where people may be able to try to do some kind of responsive action that would go after the source of the problem, regardless of, if we know where it's coming from, just by electronic means. But attribution is certainly an issue, and so we'd want to basically give whoever is responsible for making the decision about how to respond a reasonable level of certainty that the interference is intentional and who is doing it. Major Mudge, would you like to say anything more about that one?
No, I agree with you. I mean, there's got to be attribution. The traditional problems we have with attribution in the cyber realm are just as present in the space realm. So under general principles of international law, we're going to have to attribute the attack to some state function, but that's not always easy.
Hey, great. We've got another question from the audience, from Lonnie Gardner. It seems that if even reversible interference were occurring, that wouldn't on its own justify use of force. a broader context of the other acts might permit a response in any domain. So do you want to maybe speak to some of those other contextual factors that might drive your analysis on this question? And this is open up to either of you, Brian or Adam.
Yes, I think the broader context of other acts is significant. I think that's something that Prime Minister Abe spoke to in that segment that we quoted, where if you are looking at all the different activities that, that a state is doing as part of an orchestrated campaign, of which the satellite interference is one piece, then that might raise the level of the options that you might want to take in response.
Great. I had a question. You know, one of my favorite areas of the law is the state responsibility. And I know this is a big issue as well that's arising given the increased commercialization of space. So if we saw a private satellite actor that was engaging in intentional satellite interference, what are some of the international responsibility factors that would lead you to perhaps give state responsibility to a state whereby that might affect your analysis of how to respond, if that makes sense? Sorry.
Yes, it does. So under general principles of international law, you want to look at the nexus between the private activity and the state responsibility. If we're talking about a private on-orbit asset doing something, then under the Outer Space Treaty, states do have responsibility for the actions of their companies, their private licensed or unlicensed even space activity. And so that would be an area where you might have a higher degree of state responsibility for the action. It's something that if a private company is determined to be doing something, then I think states would have to be cautious before going and responding with action against another actual state, rather than seeking diplomatically or through economic means or what have you to get the legitimate authorities in that state to put pressure on the private entity that is causing the interference. Certainly we have all the possibility of negotiating and having consultations about the harmful interference through the Outer Space Treaty, through the ITU. And so those are definitely some options that are out there as well. Enforcing criminal law against a company that's conducting illegal interference that's intentional. I think any of those types of actions would be warranted. But unless there is some clear evidence that the private company is actually being driven by the secret puppet master state behind the scenes, saying, well, yeah, we're just trying to mask our involvement in this through this putatively private entity, then I think generally you're going to be limited to non-military means.
All right, I think we got time for one more question. I've got one for you, Adam. At the beginning of your presentation, you discussed some of those other potential violations of international law short of a violation of Article 2.4. Could you maybe expand upon that a little bit, talk about maybe what the most likely violations could be as it relates to satellite interference, and what some of the factors that might drive your analysis in that direction?
Absolutely, sir. Yeah, I think there are frankly a lot of other ways that we could cognize intentional interference with another state's satellites as a violation of international law. I mean, it's the contextual analysis is going to be different under each of those bases, and it could be multiple bases of violations at the same time. So obviously, the use of force it would be the most grave. Not to use the term of the ICJ, but that type of international violation against the sovereignty of another state would have the most dramatic consequences in creating the right to use force in self-defense. So I think the most likely that we would really be talking about are general principles of non-intervention into the affairs of another state. So violating their political independence with some sort of coercive intent or coercive activity. But we also have a lot of treaty-based provisions that are widely ascribed to. So for virtually all spacefaring nations are bound by the Outer Space Treaty, and it has generalized principles prohibiting harmful interference and obligating states to act with due regard for the rights and interests of other states. Again, we run into a problem with terminology and definitions, because these generalized principles of due regard, for example, aren't real well defined, certainly not in the Outer Space Treaty. So we've got to look elsewhere in international law to kind of nail that down. But all that said, intentional reversible interference with another state's right to use and explore space could easily run afoul of the Outer Space Treaty. Also the International Telecommunications Union, which does actually helpfully describe harmful interference. So we get a little bit more fidelity from that treaty. But I think those would be the primary bases I would look to. And the same analysis that we've considered for the use of force are really going to play into that. Are you harmfully interfering? Well, what's your intent? What's the effect? What's the scale and the intensity and all that stuff? So very similar analysis, but lots of different ways to get there.
Great, thank you. I'll throw this next one up to Brian, because I think it might nicely relate to your discussion on the Schmidt factors. This one's from Tom Gregory from the United Kingdom. Do you have any thoughts on addressing persistent but low-level reversible activity? So I think that's a good point to bring up, the question of cumulative effects. So do you have any thoughts on that, Brian?
Yes, and thank you for the question. So yeah, I think this goes into what we've been talking about earlier as far as the overall coordinated campaign of activity, and how any individual act standing alone might not be a problem, but then as you're starting to pile on, does it amount to something bigger in the larger context? And I think that this can certainly help to be one of the things that actually shows the intent of the state. If it's something that we can demonstrate that this is a pattern of behavior and not just some isolated random event. And I think one other thing that we should also consider under international law is the possibility of using countermeasures. So again, sub-use of force threshold, but if there are internationally wrongful acts being done by other countries, then we could have the right to respond to those, doing things that themselves might be internationally wrongful if standing alone, if we had initiated them, but they can become lawful in response to these other actions if they are explicitly directed to cause the cessation of that initial wrongful activity. So it definitely opens up some other options for states under that line of reasoning.
Great. And we've got another question, this one from Franz Vanderdunk. Should we not, in terms of interference with satellite operations, make a fundamental distinction between interference from the ground, which may not qualify as national activities in outer space, to what Article 6 of the Outer Space Treaty speaks, and activities conducted from within space, to which it does? So I'll open up to either of you on that one. Whoever pops up first can take it.
Yeah, I think this also gets at what I was talking about earlier, that yes, exactly, the Outer Space Treaty does create a regime of state responsibility for all of the actions that might be attributable to a launching state. So, activity that is conducted by a space object that has been launched from the territory or the facility, or at the direction of the state, that can all be any damage caused by that can be attributed to the state. The state can be liable for it, even if it was a private entity that did it. Whereas if people are just turning on their little private pocket GPS jammer, that's not going to be something that the state is necessarily going to be internationally responsible for. And then it would have other means, like as I mentioned, criminal law and what have you, to deal with it.
Did you have anything you want to add to that, Adam?
No, sir. I think I agree with Brian on that.